The case of the Democratic Republic of the Congo versus the Kingdom of Belgium concerning the circulating arrest warrant of 11 April 2000 for the International Court of Justice. The case had arisen when a Belgian investigating judge issued an Interpol circulating warrant according to a Belgian law concerning the punishments of serious violations of international humanitarian law to arrest Abdoulaye Yordia Lombasi, who was at the time the Congo's foreign minister, charging him as a perpetrator or co-perpetrator of crimes against humanity. In response to the circulating arrest warrant, the Congo have initiated proceedings at the International Court of Justice asking for the warrant to be recalled and that Belgium informs the countries where the warrant was circulated to that they renounce their cooperation to execute the warrant. Congo's request was based on the argument that by issuing the circulating arrest warrant, Belgium have infringed on the Congo's international right and have violated the principles of equal sovereignty, claiming that by issuing the warrant, Belgium would be exercising its authority in another state, i.e. claiming universal jurisdiction. Second, by violating the diplomatic immunity of a sovereign nation's Minister of Foreign Affairs. Shortly after initiating the proceeding, Mr. Yordia ceased to hold office as Minister of Foreign Affairs. At the time of the oral submissions, the Congo have only submitted to their second argument of diplomatic immunity. Belgium have responded by stating that the court lacks jurisdiction to hear the case and therefore the Congo's application should be ruled as inadmissible. Belgium's first and second arguments were that since Mr. Yordia is no longer Minister of Foreign Affairs, therefore there is no legal dispute between the parties. Meaning since Mr. Yordia is no longer a government minister by any means, the Congo lacks standing in the case and the case lacks standing before the International Court of Justice. Second is that the change should render the application without object, meaning that since the Congo are filing an application concerning an arrest warrant against their foreign minister, there are no outstanding arrest warrants on its incumbent foreign minister, therefore should render the Congo's application moot and that the court should decline to proceed to judgment. The court's ruling with regards to arguments 1 and 2, that at the time of the application Mr. Yordia was in fact the foreign minister and that by issuing the arrest warrant against an incumbent minister, there is still the question of moral injury to the Congo. Also that the warrant is still circulating and that the Congo still wishes to cancel the warrant. Therefore, the subsequent change in circumstances did not end the dispute between the parties and did not deprive the application of its object. Therefore, the court would proceed to judgment. Since the Congos did not submit to the universal jurisdiction element outlined in their initial application, Belgium's third argument was that Congo's oral submission stand materially different from what it initially filed. Also, Belgium's had a subsidiary argument regarding the non-ultra petita rule and asked the court to limit its decision on the issues that the Congo have addressed in their final submissions. The court agreed with Belgium in the non-ultra petita rule, however, rejected the admissibility argument as the issue was the legality of issuing an arrest warrant against an incumbent Minister of Foreign Affairs and that the issue is not materially different to the extent that it deprived Belgium any chance to prepare an adequate defense. Belgium's fourth argument was since Mr. Yordia no longer enjoy diplomatic immunity and have not exhausted his local remedies regarding his concerns for the arrest warrant and therefore the application is inadmissible before the International Court of Justice. The court responded that at the time of the application, the Congo had a vested legal interest in the matter under its name. The Congo were not arguing on the behalf of a national of theirs and therefore Belgium cannot invoke the non-exhausting of local remedies principle to void the application. In response to the diplomatic immunity of incumbent ministers, Belgium argued that immunities afforded to incumbent ministers aren't meant to shield them from war crimes. Belgium tried to rely on multiple decisions relating to war crimes, however, none of which involved diplomats. Although the court has found no direct international law to provide foreign ministers diplomatic immunity, however, the court found some grounds of customary international law to afford diplomatic immunity and the inviolability of incumbent ministers of foreign affairs of sovereign nations, and concluded that crimes crimes against humanity charges do not pierce that immunity. The court accordingly concluded that the issue against Mr. Abduli Yordia Numbasi of the arrest warrant of 11 April 2000 and its international circulation constituted violations of a legal obligation of Belgium towards the Congo, in that they failed to respect the immunity and the inviolability of Mr. Yordia as he enjoyed under international law, and that Belgium must, by means of its own choosing, cancel the arrest warrant and inform the authorities to whom that warrant was circulated to. The implications of this case is that foreign ministers enjoy absolute diplomatic immunity and inviolability against crimes against humanity unless the country of nationality revokes diplomatic status, although the court considered that protected diplomats should not enjoy impunity. It did not discuss when these actions are considered impunity.